Good afternoon. As Ankit mentioned, my name is Paul Allers. It's my privilege today to be presiding today with my colleagues, Judge Mary Cicchelli and Judge John Sandy. We have 3 cases set for this final session of our September oral arguments here in Des Moines. The first case is State v. Zanoni, case number 241081. Here representing the appellant Zanoni is attorney Denise Gonyea. And here representing the Appellee State is Timothy Howe. And Ms. Gonyea, whenever you're ready, you can begin your argument.
Thank you. May it please the court, counsel. I'm here today on behalf of Michael Allen Zanoni, Jr., who, as the court is aware, is currently in prison serving a 50-year sentence for, among other things, principally possession of methamphetamine with intent to deliver. While there are several issues of constitutional import that I have presented in my written briefing to the court, I would like to concentrate on one that I believe occurred early on where everything kind of went awry, to put it mildly, which is the issue of the motion arrested judgment and the court and the trial counsel's refusal to enforce the plea agreement that was not just a negotiation at the time or something being considered, but was actually entered on the record to the court at a plea hearing.
Of the 6 issues you've raised, is that your strongest one, you think? I'm not asking you to concede anything, but do you think that's your strongest?
Yes.
And you're claiming the plea agreement that was embodied in that June letter. Is that the one we're talking about? Is that the issue?
The plea agreement that was, well, it was mentioned multiple times throughout the record, and there was an actual plea hearing with a transcript of the plea being accepted by the court early on, back in, I believe it was November of 2022. And then the defense counsel asked to enter a motion of arrest of judgment based on what he believed was the defendant's complaint that the matter was not voluntary.
So he filed a motion of arrest of judgment trying to get out of the plea. Judge Ellison let him, right?
So the defense counsel filed the motion, and on the record, the defendant said that in fact he did not want to take back his plea, and what he really wanted to do was have a different attorney at sentencing.
Did you brief that issue?
That is included in the number 2 district court erred by denying Zanoni's motion to enforce the plea agreement.
Right, but the plea agreement mentioned in your briefing on that is that letter, right?
That was the culmination before trial. The ultimate defense attorney asked to enforce that plea. Well,
there was a plea confirmation letter dated June 20, 2023, correct?
That's correct.
And that's the one you're trying to enforce?
That was a reiteration, I guess I would call it, of the original plea agreement.
No, that was different than the plea agreement I think put on the record that your client pled guilty to and then backed out of through the motion and arrest of judgment. And I think it might have happened after that, because he filed his motion and arrest of judgment on January 11th of 2023, and the plea confirmation letter is dated June 20, 2023. And I don't recall your brief making any complaint about I know there's in the record, there's some complaint where your client was talking about, I don't want to back out of my plea, I just want a different lawyer. So Paul Rounds filed it as a motion and arrest of judgment. Judge Ellison let him out. I didn't see in your brief where you challenged that action.
Well, Judge, in going back over and preparing for oral argument, this is something that I saw and it seemed to fit into the heading under the motion to enforce the plea agreement. I understand where the court where is saying that you're saying that those are really two completely different pleas. So if there is something that you would prefer that I concentrate on, certainly I would defer to questions that you would have. And
well, no, I'd like to focus on the stuff that you've briefed. I mean, I think that's fair. I don't think we can address stuff that you didn't brief. And if you did brief that, I'm open to you telling me where you did that, but I don't see anything in your brief where there's the complaint about this whole rounds filing a motion and arrest of judgment issue. I guess that's not the thread I picked up from your brief on that. I picked it up as that June 20 letter, but maybe I misunderstood.
The court is accurate in that in the briefing, I concentrated on that later June letter. That's correct.
Thank you. Go ahead. I guess I don't have any questions related to that unless that's something, is that, when it's limited in that fashion, you still think that's your strongest argument?
No, in addition, I believe that there was quite a few issues right up to trial, one being that the newest attorney was not granted the additional continuance to really prepare for a trial, and the ability to present a defense, of course, is critical to the ability for a person to represent themselves.
So the trial date that actually occurred was the 14th time the case had been set for trial by my count. And a week before that, when the 13th trial date was set, if I understand the record correctly, and please correct me if I'm wrong, your client testified at the hearing on that motion to continue the 13th trial date and basically said, you know, it wasn't his preference to only get a week, but if he got a week, that would be better. And so the judge gave him that week and continued it, and then the day before that 14th trial date, he asked to continue it again, and the judge said no. I mean, is that a fair assessment of how it went down?
Judge, I would say that that's a fair assessment, but I would point out that this was the fifth attorney in this series of attorneys representing this.
Actually, but yeah.
Was the sixth. And while that's certainly not an ideal situation for a defendant, as I did mention in my brief, the measure of whether a person is prepared or not for trial is really the attorney that's going to be presenting the defense at trial, not the five that came before, and they could have been prepared, but the one that is actually having to do the work and having to go through all the video and meet with his client who is in jail at the time is the one who needs the preparation. And while I think that attorney was trying to understood the court's concern and unhappiness with having a continuance, that maybe he a little bit overstated what he thought he could accomplish, but considering the severity of the crime and the 50-year sentence that my client's serving, it would not have prejudiced the state to provide that additional time.
That your client had redemanded the 90-day speedy trial, and given the available trial dates and defense counsel's schedule, there were problems rescheduling if they didn't go when they went, right?
That's correct, Your Honor, and I do believe that the record states that the defendant was willing to waive that 90 days if that was necessary in order to.
Right, he didn't. Because he'd also said he would waive his 1 year, and then he's filed multiple motions to dismiss on that basis. So Mr. Zanoni probably didn't have a great deal of credibility on his claims that I'll waive speedy trial, right?
Well, I'm not going to certainly argue that he was maybe the easiest person to work with, but it's not, of course, uncommon for someone to want to waive speedy trial if it's going to give them the time they need. And it's also not uncommon for a defendant to assert speedy trial, then waive it, and then reassert it again.
Sure, and they're entitled to do that, so I'm not criticizing him for doing that, but I'm just saying the trial court was, and this is on the record, was kind of in a pickle here about, I can't keep continuing this. You've got a speedy trial deadline. We've got limited numbers of trial dates coming up. You've got two cases, and we can't have the same jury panel for both of them. You've redemanded on both of them, so we've got to cram in 2 trial dates within the next 3 weeks. And your lawyer has, it might have been a murder trial over in a different county. in between there. So where are we putting this date? And nobody had any idea for a date, right?
I think that's correct, if the speedy trial wasn't waived. But again, while there was no speedy trial waiver entered on the record, I think that the record was clear that he was willing to do that. Whether that actually happened was kind of we don't know if that actually would have happened or not because there was no continuance given.
Part of the thread that runs through here too seems to be because Mr. Clausen, who was the sixth attorney and the one that actually tried it, looks like he'd been on board for a little over 2 months by the time the case was tried. So it wasn't like he got it 3 days before type of thing. And there seems to be some suggestion, either by comments Mr. Zanoni made on the record or maybe in the briefing, that this case was complex. And I realize there were a lot at stake in terms of the potential prison time involved, so I understand that. But as far as complexity goes, this doesn't strike me as being that complex of a case. I mean, this guy's seen doing suspicious stuff in the parking lot. And he's on video, or at least still camera of him of that. He takes off running when the police arrive and ditches a backpack that the police find with information linking to him. That's the state's case. I mean, this whole notion that, we need another, month to look at videos, what are we looking at? I mean, it doesn't strike me as being that complex a thing, that this all smacks of, I'm trying to stall this, right?
I understand the court's point here, and I would say that maybe complexity is not the right word, and I know that's what the defense counsel used. However, there was a lot of video evidence, and what the defense counsel, I think, was wanting to do is to go piece by piece through that video evidence, because while there was a person on the video, a person did run, and there was a backpack. The way the court stated the facts are what was ultimately found. However, on my client's behalf, it was asserting that it was not his backpack. There was, in fact, a lot of women's items inside the backpack, and that there was discrepancies in the video that could have been pointed out if there had been enough time for defense counsel to really go through all of the video that was there and compare that to the statements of the defendants, including this Officer Barney, who had arrested I don't think she ended up being a co-defendant, but a person that was there at the time who in another situation stated that Zanoni was with her at that time. And there were these kind of discrepancies basically that needed to be parsed out and paired with their particular evidence, whether it was a live witness or the video, in order to refute those kind of cut and dry facts that the state was putting forward.
Thank you.
And to kind of finish on that, the state's choice to not call Officer Barney created a situation for my client where he missed out on an opportunity to have this police witness provide testimony that would assist in the defense that Zanoni was actually in a different place at the time.
They'd have the obligation to call a witness that has favorable information for the defense. Why doesn't the defense have the obligation to get that witness in?
So there would be, the idea that there would be the defendant would be required to subpoena this person. However, because this was
all the time, right? I mean, if the state has minuted witnesses and some of them have information, as a defense lawyer, you subpoena them to make sure they're there, right? To make sure the state doesn't not call them, right?
Point out that because this was a police officer witness who was originally listed in the minutes of testimony, that it put that particular witness in a position that the state would need to provide that person because they had given notice that this person was going to be part of the trial.
Thank you. And you're out of time, but you'll of course have your 5 minutes on rebuttal. Thank you. Whenever you're ready, you can begin your argument.
Thank you very much, Judge Allers. May it please the court, counsel. Good afternoon. None of Mr. Zanoni's claims entitle him to relief, and this court should affirm all of his convictions. I'll start where we left off, talking about the inability of Mr. Zanoni to depose Officer Barney. This is unremarkable. The state has no duty to call every minuted witness to trial. It is important for defense counsel to prepare their case and subpoena the witnesses they believe to be necessary.
You know, maybe I've got this wrong, but just from 9 years on the trial bench and here, it's a fairly common practice, is it not, for defense counsel to subpoena minuted witnesses to make sure they're there if they've got a piece of the puzzle that's helpful? Okay.
The nature of the questioning. Cross-examination and its limited scope and the answers that you're trying to get from a witness would make it important if you're looking for descriptive events or a larger part of the narrative. You would call them as a direct witness so that you could elicit that from them. So if Mr. Clausen wished to deliver or to elicit that sort of evidence from Officer Barney, it was imperative that he call him to trial. But I think if we look at the minutes of testimony, which Mr. Zanoni has had since October of 2022, nothing Mr. Officer Barney was going to say was going to have any impact on this trial. He couldn't have spoken to the hearsay statements of Abra Curvin. Frankly, if this is an attempt to build an alibi defense?
If I understand it correctly, what Mr. Zanoni wanted to do was call in Officer Barney to say that some other person had said that Zanoni was with her when the crime was committed.
Correct, which is not even inconsistent with the state's narrative at trial. At trial, Greg Widener called 911 because he was concerned about what he was seeing in his backyard. Officer, I believe it was Kaufman, drove by, and Zanoni fled. Fled where? We don't know, but to somewhere else, and then returned to that location. Even if Abra Curvin said he came inside my apartment, it would fit within the period that Zanoni was not seen by Widener or Kaufman. And then Kaufman comes by again, Zanoni flees again, and then Kaufman, in an attempt to pursue him, sees Zanoni initially without the backpack in the parking lot, and then later without the backpack. And after he loses sight, does an attempt to pursue a person in a car, stops, backtracks, finds the backpack. So nothing that Officer Barney would have said talking to Abra Curvin in an unrelated traffic stop somewhere and around the same time would have had any impact on the state's evidence that it produced in this trial. I would like to also just backtrack quickly to the question of continuance. Mr. Zanoni has been incredibly lucky in this litigation that he was granted not one, not two, but I believe 3 11th-hour continuances. On March 25th, after Attorney Clausen had been appointed to the case, everyone said that we were ready to go to trial. And then at some point between March 25th and April 9th for the pretrial conference, something changed. Some amount of uncertainty as to trial preparation occurred. So trial was moved from April 9th beginning to April 10th to give Mr. Clausen an opportunity to redepose all of the state's witnesses, which had been deposed by Attorney Wilson earlier in the case's pendency. And then again at the April 9th hearing, Mr. Zanoni asked for another continuance, the week-long one that resulted in this being on April 15th. And Judge Allers, I'd like to just say that your instinct that this smacks of delay is on point. I mean, immediately after he gets a 1-week continuance to April 15th, he seeks another one to April 16th, and then seeks another continuance on the 17th and the 18th, both days of trial, complaining of illness and a need to stop the proceedings to address the illness. Mr. Zanoni simply did not want to go to trial, or at least wanted to whipsaw the state back and forth as to his intent to do so. And part of the reason I say whipsaw, because that's a verb that has a little bit of juice to it, is that he waived his right to speedy trial the 1 year in issue 1 of the brief twice on the record in front of a judge, and then again in a written filing. I understand Mr. Zanoni believes that that written filing is defective. However, under the rules of electronic procedure, such a minor error, if we're even going to call it a typo, in the caption of the case didn't prevent it from being correctly filed in the right case number inside of EDMS, and the court could the clerk, could overlook that via 16308.
Does the rule provides that to waive the 1 year speedy as opposed to the 90-day speedy, the defendant has to do it personally, either in writing or on the record, right? It's an either-or situation.
Exactly correct, Your Honor. Correct.
And if I'm reading the brief correctly, the only one that he challenges is the written, and only because of the typo with respect to the county name. All right, but does not challenge the on-the-record waiver.
Valid and remains, he might, I shouldn't speculate, I'm sorry. Please continue.
I'm good, thanks.
I I would like to talk briefly about the eve of trial motion to enforce plea agreement. I recognize I've probably complicated the matters by suggesting that we have a different standard of review, but I think it does matter when we're talking about whether or not a contract was even formed versus whether or not the district court abused its discretion in enforcing a contract between the state and a defendant. Whether or not a contract was ever formed is a question of law that this court can decide, basically anew. But abuse of discretion, we would give more deference to the district court. However, whatever the standard of review this court applies, this motion to enforce plea agreement, I think the district court was squarely within its discretion to find was filed in bad faith. After he had been denied another continuance, there was a simultaneous motion to dismiss and motion to enforce plea agreement, anything to get out of going to trial. I don't believe that an agreement to agree, which is what I think the June filing that was brought out at the motion to enforce plea agreement, was ever an enforceable contract. I think I'm always a little hesitant to compare guilty pleas and contracts as an equivalent. It's another entire body of law. Certainly our Supreme Court has suggested that the concepts can be similar. But here to have an enforceable contract, we need more than just an agreement to an agree between the state and silence from a defendant. Mr. Zanoni has never waived his trial rights, after the initial unsuccessful guilty plea that he sought to withdraw. After this agreement to agree was reached, he never waived his trial rights. He never asked for a plea hearing. He simply got a new attorney and started preparing for trial again.
Based on your briefing and the comments you've made here, is it your position that there could unquestionably be a meeting of the minds where the state says, here's a deal, just to make up a scenario, you're charged with these 5 crimes, counts 1 through 5, we'll dismiss counts 2 through 5 if you plead to count 1, and agree to the maximum sentence and no probation, what have you. No question the deal is offer, acceptance, both sides, we got a deal, maybe even put it on the record. Is it your position that the state can still back out of that for no reason until the defendant actually enters the guilty plea pursuant to that plea agreement?
Absolutely. I think that's consistent with what we say. And just to walk myself back one moment, it's because even if the parties have an absolutely stone-cold terms agreement, if it's not accepted by the district court, it's nothing. It's nothing that the defendant could hold the state to later. All that would happen would be exactly what happened in this case. Trial would occur, and the state would put on its evidence in pursuance of its charges, and a verdict would follow. So again, I agree with you. Yes, the state could back out.
Cases that talk about how the plea agreement has to be scrupulously honored in the sentencing context where the defendant has entered the guilty plea, and then the state kind of waffles or, kind of...
Exactly correct, because at that point, what has occurred is that the defendant has waived his trial rights in exchange for the state backing out of the deal. To be clear, that is unacceptable. But before a judge has accepted the defendant's waiver, the defendant is not out anything. There would be, yes.
Would you still hold that, though, if there was detrimental reliance? And what I mean by that is, like, let's say, the defendant thought a deal was struck, didn't prepare for trial. Maybe the defendant waived some trial rights, speedy trial rights or what have you, didn't participate in certain motions to suppress because, we thought we had a deal, and then the state backed out. Would your opinion change on that at all?
I would certainly want to be confronted with those specific facts as you're giving me, and I think there are a lot of instances that we can imagine where there would be detrimental reliance. I think of proffer agreements specifically, and that's going to be a different case than what we're talking about here. So
If detrimental reliance does apply, there isn't any here, right? The record doesn't show any reliance.
Dollars.
In fact, if I'm not mistaken, during one of the hearings, I think the trial court asked defense counsel, can you point to anything that shows that Mr. Zanoni did anything that was consistent with having an agreement? And he said, well, other than not withdrawing, we don't have anything.
Correct. And again, in one of the more interesting techniques I've seen in this trial, Attorney Clausen calls his client to speak and provide testimony I assume, to build a record in support of the motions that he's filing. But as we've seen through Mr. Zanoni's on record, his credibility is extraordinarily suspect, and his assertions that he always thought he had a deal is completely belied by his conduct in preparing for trial moving to dismiss this prosecution, moving to continue it, not for purposes of a plea hearing, but for trial. So for all of those reasons and the other ones stated in our brief, the state would ask that you affirm each of Mr. Zanoni's convictions. Thank you.
Ms. Gonyea, you've got 5 minutes of rebuttal if you'd like.
Thank you, Your Honor. Of course, the state's arguments, and I guess I would say at the end of the day, we have a gentleman here who was, sounds like coming across to the court as being difficult, delaying, wanting to delay. But we've got to remember at the same time, he was in jail this entire time. He wasn't trying to avoid the inevitability of incarceration. That was already happening. So I think that while he certainly didn't streamline the process, I don't think that necessarily there was intentional delay. And really, you know, at the end of the day, he has the constitutional right to present a defense. It is not uncommon for anyone in a defendant or any kind of really, whether it's a divorce case or a litigation case, to simultaneously prepare for trial and negotiate a plea at the same time. So,
Can you point to anything, because I know trial counsel couldn't, but can you point to anything in the record that is consistent with Mr. Zanoni having a plea agreement that he intended to follow starting on whatever date it was, June 20 of 2023, so approximately 10 months before trial?
I think all we have on the record is that letter stating that, yes, the plea agreement's going to be accepted by my client. To go back into the minds of the various attorneys, we just don't have that. But we do see that Mr. Zanoni did previously try to plead guilty in this case and did go through with the process. So since he did it once, my guess is that he knew what was going to happen and wanted to go through with it again.
Well, he also said he wanted to waive speedy trial and then filed a motion to dismiss, claiming that he didn't waive speedy trial, even though he clearly had on the record and had also done it in writing, right?
That's accurate, and honestly, I think that maybe was kind of a Monday morning quarterback sort of thought process that he might have had there in raising that issue. And he did, as you could see from the record, have these periods of time where he had counsel and then had some sort of falling out and then felt that he was representing himself. And I think that really kind of muddied the waters. But like I say, at the end of the day, he still has that right to have that speedy trial. He can waive it with his assistance of counsel, which he had at the end, Mr. Clausen. And because there was kind of this, these 11th hour, this isn't, trying to putting a kid to bed who wants to keep getting up and getting a glass of water, right? This is someone who's looking at 50 years in prison. So I think maybe it would make more sense in a constitutional light to give him the benefit of a doubt when it comes to presenting his defense.
Do you agree with the state's position that even though you might have a rock-solid plea agreement, that until the defendant actually enters the guilty plea, the state can pull out of the agreement?
No, I don't think that's accurate.
Yeah, clarify, either detrimental reliance or the defendant enters a guilty plea pursuant to the agreement, assuming the agreement calls for him to enter a guilty plea.
I don't think that's accurate, and I think that the principles of that negotiation, while they might not always make it to the official record, there's some things that go on in those negotiations between the attorney and the state and, through the defendant with the mouthpiece of his or her counsel, possibly giving up some of these important things. Well, he's going to admit to this if we can get this. So it does put him in a position where he's not just starting from scratch going to trial.
But he enters the agreement in June, trial's in April, so about 10 months later. during that entire, other than the night before trial or the day before trial. Tell me if I'm wrong. He never advised the court that there was an agreement. He never asked to set a plea hearing, which he had done previously when he entered the plea. That's how it got set, was he asked for it. So he knows how to do that, or is familiar with the process. About a month and a half after the letter, he participated in a hearing at which he waived his right to be brought to trial within 1 year of arraignment, which would be unnecessary if he intended to enter a guilty plea. There were 9 different trial dates set, and he never told the court, you don't need to set a trial date. I'm pleading pursuant to this June 20 plea agreement. He moved to dismiss the charge, another thing that would generally be inconsistent with there being a plea agreement. He asked to redepose witnesses, something else unnecessary if he's going to plead guilty, right? All those things are true, factually, procedurally, right?
That's correct. And I guess I'd say that Mr. Zanoni's understanding of the law and in thinking, what these items pro se that he is filing created a difficult situation for both.
Sophisticated to say to your lawyers, like, hey, why aren't I going in for the plea hearing pursuant to this deal I got cut? I mean, it doesn't take a lot of sophistication to do that. And Mr. Zanoni showed that he didn't really have much difficulty kind of pushing his lawyers on stuff, right? When he had an idea, he got his message across, right?
I believe that it's accurate, and maybe with the assistance of counsel at the end of the day, that got revisited more toward trial, saying, look, we're going to trial, why are we here? And he didn't have the benefit of having that counsel up to that point.
Thank you. Thank you, counsel, for both sides for your efforts and your briefing and your arguments here today. Appreciate them. We will consider State versus Zanoni submitted, and we'll get a ruling out as soon as we're able. Thank you.